Hello there, sir. May I know who I'm speaking to? How do you spell that? Yeah. Howlett. Okay. Yeah. My name is Anthony Badaloo, so I'm a financial advisor. I'm an accountant. I have a little knowledge about this matter, and I think the Mrs. Jackson has made all the effort humanly possible to rectify the situation. There is a very, very clear matter of fraud upon the court, and she has made submissions in writing to the court and the bailiff and the police. A crime report has been filed. Now the police told her it's a civil matter, so obviously then you shouldn't be there if that's the case. But the problem is, I understand there's a warrant there in question, and my limited knowledge of the Warrant Act is that the warrant has to be served upon the individual 14 days beforehand with a notice of issue and a copy of the receipt for the fee paid for the notice of issue from the court. And the warrant has to be sealed by the court under the County Court Act 1984. If a warrant is not sealed, it's a forged instrument. It cannot be relied on to remove someone from their home. Yeah. Well, you can't evict, with due respect, sir. I'm sorry, I don't mean to talk across you, but you cannot evict someone with a notice of eviction. You can only evict someone with a warrant, a proper lawful warrant, properly executed and administered in the justice system. You can't just turn up at somebody's house with a notice of eviction, which is probably not being sealed by the court, not being signed by a judge. It doesn't matter, sir. All those correspondence are irrelevant. The only yeah, sure. Yeah, the only instrument of law that can allow that Mrs. Jackson to be removed from her property by force is a lawful, properly administered warrant. Anything else, sir, is completely irrelevant, and I can give you my assurance I have done a certain amount of work on this matter. There is a serious abuse of process, and there is no lawful document. Even if they did have a proper warrant sealed by the court, it should have been served on her 14 days in advance, so she would have the opportunity to either challenge it or pay the money that they claim, or challenge it in court if there is a problem. You cannot just turn up at somebody's address with a notice of eviction, which is it's not a valid document in any case, but it doesn't allow you to evict someone. Only a warrant, sir, with a notice of issue. And this is not civil law, sir, but what I'm telling you, I appreciate. I'm telling you with some authority, sir. I've been in the business nearly 30 years now. I'm telling you very strong authority. You can write my name down and hold me accountable. That if they do not have a valid warrant, yeah, Mr. Howlett, if they don't have a valid warrant properly issued with the due process of law and sealed by the court, they cannot evict. And you are the police. You are there, sir, to prevent a breach of the peace. And if these people attempt to evict this lady without the proper due process, it is a criminal raid and harassment under the Protection from Eviction and Harassment Act 1977, which is a very serious crime. It's not a civil. So you, Mr. Officer, will be guilty on the pace of being a part of the crime if you allow it to happen. Page section 24, sir. It's all to do with it. Okay. Okay. Yes, Murray. I gave him the chapter and verse. It turns out it looks like they don't have a warrant. Well, fine. It's not a warrant. If it's not sealed, it's not a piece of paper. So I read the officer Howlett chapter and verse, and I told him on the pace he's fully accountable. If he said it's a civil matter, I said it's a civil matter until such time they break the law under the Protection from Eviction and Harassment Act 1977. Then it becomes a criminal matter, and if you stand there and allow a crime to take place without the lawful due process, you will be a part of it. He says, no, I'm not a part. I said, on the pace, section 24, my friend, you check it out. You are part of it if you allow a crime to take place without the, yeah. So I think it's sunk in his head pretty good. They're trespassing. Tell them, ask them to leave. They're trespassing, ask them to leave. Because apparently there is something, if you don't ask them to leave, you know, they become a trespasser at the point when you ask them to leave. So you say, you're trespassing, please leave my premises. You have no lawful instrument to be here. A notice of eviction is no good. They need a proper warrant sealed by the court and signed by a judge. Yeah, so you don't go outside, shout through the window, please leave, you're trespassing. Tell them they're trespassing, please leave. Yeah. Anyone, the chief one, the one in charge. Okay, well, what I was telling your mom to do, somebody in the house need to shout at them through the window. You have to tell them they're trespassing and they must leave. Because what it is, if you don't ask them to leave, if someone enters your premises, they're okay. But when you ask them to leave and they don't leave, then they become a trespasser. I spoke to the officer, and from what he told me, they don't have a valid warrant. So they can't... Who is saying they have? They have what? Okay. Yeah, gosh. Now, it has to be by a judge. It has to be sealed under the County Court Act 1984. I told the officer straight. Not only that, you haven't had any notice. You have to have the notice of issue 14 days in advance with an opportunity to respond. Yes, the warrant should be attached to that's the due process of law. I told the officer very clear, I think he digested it. I have a feeling they will go in a minute. But one of the things is, somebody need to pop their head out the window and say, please, you're trespassing, please leave. Good. Because if you don't do that, apparently they're not official. Once you tell them that, they now become officially a trespasser. Protection from Harassment and Eviction Act 1977. They cannot enter your house. It's not a lawful instrument. What they have in their hand is a paper. It's not a lawful instrument. For the time being, it's not just simple. It is not a lawful document, and it's not been served. It has not been served. Yeah, it has to be correct to the letter. County Court Act 1984, it must be sealed or it's no good. Because he could have made it up in the back of his van. You guys are doing tremendously well. I'm very sorry I won't be there today, but I spoke to the officer, Howlett, and the way I think he accepted everything I'm saying. So hopefully, yeah. I told him right down. He was telling me it's a civil matter. I said to him, Mr. Howlett, PC Howlett, it's a civil matter until such time they break the law from the Protection from Eviction and Harassment Act 1977 and the County Court Act 1984. Yeah, it says the document has to be sealed. That's a seal, not a button stamp, a proper code stamp with a date and signed by a judge. No, well, you dispute it. It's not. Because they cannot have a proper warrant when there's been no process. There's been no notice of issue and a receipt for the fee paid for the notice of issue that they serve you 14 days. So if they actually claim to have a document, it's guaranteed it's a forged instrument. No, when they send you, they're supposed to, Bob, who are you speaking to? Oh, yeah, you have not been served with an, let me talk to put the bailiff on the phone to me. Well, tell him it's, okay, well, let me talk. There has been no notice of issue with the attaching receipt for the fee, and any document you have is not a lawful instrument because there was no due process. Full stop. So any activity right now, that means they have to follow as the law lays it down, that they have to get permission for a notice of issue. Then they have to serve you the notice of issue with a copy of the receipt that they pay the fee and the opportunity to challenge the matter. You can't just turn up at somebody's house with a piece of A4 paper. Yeah, and the receipt for the fee for the notice of issue. It's not, what they have there is not a lawful instrument, full stop. Lawful instrument it is not. Is he near you? Ask him if he has a EX96 full. Is it signed by the judge? No, that's not good enough. You can't kick me out of my house saying it's as far as I know. Huh? Yeah. Well, you've had no process. You've had no due process. You've not been served with any. Marie has not had any service of anything. No. Where's the notice? Tell them to show you. They need to provide evidence you've been served. You've not been served. You've been to court to say you've not been served, and you intend to take the matter to the High Court. Is the warrant sealed and signed? Well, then they should go away. Tell the police to ask them to leave. No, then it's not good. Anybody can put some ink on a paper. Yeah. I mean, how are you going to tell if something is forged if it's not signed? County Court Act 1984. Yeah. Did somebody ask them to leave? Did you tell them they're trespassing? Okay. Is someone videoing? Good. Did they show an ID? All right. Anything, just give me a show. I'll stay on standby here for you. All right. Cheers.